Good morning, Ms. Manor. Good morning, Mr. Palepan.
Good morning, Chief Justice Marshall, Honorable Justices of the Court, Madam Clerk. May my argument please this Court. The case before the panel is the Commonwealth's appeal of the motion judge's allowance of a motion to suppress and the appeals court's affirmation of that decision. The facts that we have before this Court, I would suggest, are rather unique, and this Court has a similarly unique opportunity to establish law.
Did you reach the conclusion that that suitcase had been abandoned?
Yes, Your Honor.
And so it follows if it was abandoned, the police could open it up?
Absolutely, Your Honor.
In spite of the fact that it was a closed container in an apartment that they controlled. It seems like the appeals court said you've got to look at more than just the words.
And I would agree, Your Honor. In fact, that's the Commonwealth's point. In this case, the police, number one, had lawful access to the apartment. They dealt at arm's length, face-to-face, on two occasions with the occupants. On the first occasion, which was about 9:45 in the evening, Mr. Aragoni, another in this case, one of the occupants, was present. He allowed the police in. He disclaimed any ownership in the suitcase, indicated that it may well belong to Mr. Augello, the second named defendant, who's the occupant. The police vacate the apartment. They return 45 minutes later. The suitcase is still there. They also find the second occupant, Mr. Augello.
Here's what the appeals court said. I think when you boil it all down, it says, in essence, the Commonwealth takes the position in this case that an oral disclaimer of ownership is dispositive on the issue of abandonment as matter of law. We disagree, and the case law states otherwise. They cite to Posco and Straw. Here, as already noted, the place where the suitcase was found was the defendant's apartment, and the items were in a closed container and not in plain view. Thus, the location was subject to the highest constitutional protection, and the expectation of privacy without question was legitimate. In short, the objective facts and the actions of the defendants in locating the objects belie any intent to abandon the objects. These factors must be taken into account along with the words of the defendants in determining intent.
The appeals court took a much too narrow view of the Commonwealth's argument.
They got it wrong.
They got it wrong, Your Honor. And the reason why they got it wrong is simply this. Unlike the cases cited like Straw and Pasco, in which there was no verbal disclaimer of ownership. In fact, in no case in the Commonwealth have I found a verbal denial of ownership. This is an abandonment case by word, not by deed. And that's the key distinguishing point here.
So you are saying an oral disclaimer is dispositive. That's what you're saying.
It's important. No, it's not dispositive, Your Honor. If the oral disclaimer was coerced, much in the way of consent, then it could be negated. Because after all search and seizure law depends upon reasonableness. And in fact, the law of abandonment takes into consideration one's intent as shown by words, acts, and deeds. Here we have all three in combination, the words, the acts, and the deeds. When the police first arrived and questioned them about the suitcase, they left, and when they returned, the suitcase was still there.
And that's an act of abandonment? If it had been out in the hallway, I'd say that would be an act of abandonment.
The act of abandonment is when the police at arm's length and face-to-face asked both Mr. Augello and Mr. Aragoni for the second time, is that your suitcase?
Is that suitcase, which contains incriminating evidence, which is right here in your living room, is that yours?
They didn't ask for consent to search the suitcase. They asked, is that yours? And that's a distinguishing factor. At that point in time, both Mr. Augello and Mr. Aragoni said, no, it's not mine.
Therefore, albeit it's in the middle of your apartment, it's abandoned, and we'll take it. Thank you very much.
Well, but here again, the police are relying upon the stated disclaimer by the defendants in conjunction with the fact that when given an opportunity to hide it, as Mr. Straw did when he tossed the suitcase out of the second-floor window when police are going through the front door, these individuals did not hide the suitcase. They took no effort to place it outside the reach of the police.
So let me ask you this. If the police had come back for the second time and the suitcase was not where it was, you couldn't see it, that would, but the roommate also said, yeah, that suitcase was not mine, that would be different because they had moved it out of the room?
It would be different only because if the police then asked, where's that suitcase, and they both both denied not only ownership but any knowledge of where it was, then the police would not be in a position to seize it or to search for it. Here, I'm sorry, Your Honor.
Go ahead. No, go ahead.
Now, here, by contrast, there was no effort made to place the suitcase beyond the reach of the police, who came back the second time, and the suitcase was there.
But was there any indication when the police left, after the first time, that they would be back? In other words, did they tell Mr. Aragoni that they would come back?
Well, I think it's implicit that the police were investigating the breaking and entering. The first time they were there, they seized the 2 bottles of liquor that the motion judge suppressed. So clearly, the investigation had focused upon them.
But I guess is there anything more than somebody with a little reason might think, oh, they might come back? But he didn't say, the officer didn't say, I'm coming back on the hopes that Mr. Augello will be there. He didn't indicate anything about returning. This goes to the point about whether we should make anything of the fact that the 2 men did not move the suitcase between first and second visits.
Well, I think it simply defies reason for the individual not to believe the police were interested, especially after he told the police it belonged to his roommate, and he tried to steer them towards his roommate by saying that the Maestro gym bag on top of the suitcase belonged to his roommate. So clearly, anybody, I would suggest rather that the strong inference was the police would then go to the roommate, and when they came back the second time, 45 minutes later, they were looking for the roommate.
Was there a basis for the police to get a warrant to seize and open this suitcase?
That actually, Your Honor, is a tight question that I think is speculative, because the police, unfortunately, there was not an evidentiary hearing conducted in this matter. It was submitted to the court upon the police report, which did not identify the witnesses that provided detailed information to the police.
But I mean, based on what we know, and I may not have all of it straight, but they found some of the liquor bottles that belonged to the store or whatever it was.
They were consistent with those stolen from the bar.
And
Right.
you could draw an inference that other bottles could very well be hidden in a suitcase. There was information, was there not, that whoever stole the liquor was carrying a black suitcase?
Yes, and that.
So they had
yes.
not a clear, but an adequate basis on which to get a warrant.
But Your Honor, I would suggest that to argue that a warrant could have been obtained ignores the larger question of whether or not we have abandonment here. Just because a warrant could be obtained does not, I would suggest, fault the police for opening an abandoned piece of property.
Let me ask you about the concept of abandonment. There's something, if you're relying on a concept of abandonment, it strikes me that maybe you should be judicially estopped from arguing at the trial of this case that this property belonged to the defendants. I mean, you know that they were lying, and you took advantage of the fact that they're saying it's not my property, and now you're claiming it's abandoned property. You're not saying that it's their statements that we're relying on. You're referring to it's almost like an in rem kind of a statement. This is abandoned property. If it's abandoned property, how can you then say it wasn't abandoned property at the time of trial for purposes of linking the defendants up to this property?
Well,
But we let the defendants do that all the time. They have standing for purposes of the motions to suppress. And then at trial, they can deny that the item was theirs.
Yeah, but this is you're
Commonwealth,
talking about abandonment of property. It's sort of an in rem kind of a statement. It's not a statement having to do with the defendant's state of mind.
No, I think as Justice Cowan alluded to, the answer to that is in the garbage cases, in which people abandon their garbage alongside the road, and we rely upon evidence to link the garbage to them. The abandonment merely is the evaporation of an expectation of privacy, but other evidence of nexus to the defendant, for example, the fact that it was found on the property, the fact that there was other items of personal identifying natures found inside. Similarly here, in this case, if this matter were to go to trial, I would hope the witness who told Detective Ordina they saw these individuals carry a black suitcase away from the bar towards this address would testify to link them to that suitcase. And furthermore, I do not believe that the Commonwealth should be stopped, as the court suggested, from claiming simultaneously that merely because one has abandoned property doesn't mean that they at one time possessed it. I can possess something today, tomorrow I can throw it away and still be charged with receiving stolen property today. So I think that answers that question.
Can we flip this over? What if one of the defendants had said, yes, that's my suitcase, then what would have happened?
Then you have to ask for consent.
And the
Or get a
person-
warrant, or get a...
Or get a warrant. And Justice Ireland, you make a very good point here. When the officers come back at 10:30 or 10:45, I forget when it was the second time, both Augello and Aragoni are there. They are, again, both asked, is that your suitcase? Both say no. One says, is that your gym bag? And Aragoni says yes. So they certainly were not operating in a blind, haze here about, I'm going to deny everything is mine. Is that your clothes? Is that your stereo? No. They said, that's mine, that's not.
But
They made the choice to say, that's not mine.
With respect to that gym bag, this is, I know, not exactly on point, but if I understand correctly, the motion judge suppressed what was found, because there's a liquor bottle in there, right?
Yes, there was, Your Honor.
Suppressed that, and you're not contesting that, is that correct?
Unfortunately, Your Honor, I'm falling on my sword here. I should have raised that as an error in the factual scenario. But I still think that, notwithstanding the fact that the judge suppressed that liquor bottle, the court can take notice of the fact that when confronted with different pieces of property by the police, they said, that's mine, that's not mine. And so I would suggest that here, even if we were to, as I was suggesting to Justice Cordy earlier, looking at all the factors of reasonableness here, where the defendants themselves are picking and choosing which property is theirs, they can certainly pick and choose which property they choose to abandon.
But I guess I'm thinking this, I take it that, I don't know this, I can't remember what the judge said, but it must have been on the consent was not voluntary, because I believe was it Mr. Augello's bag?
Mr. Aragoni's bag.
Aragoni's bag.
Did the judge say that it was tainted by the unlawful?
Yes,
I thought it was because the judge said it was tainted by the unlawful search of
It
the
was
suitcase.
essentially fruit of the poisonous
But
tree.
I thought the bag was first.
The gym bag was first.
So then
Yeah.
my question was going to be, how did it get tainted by the unlawful search of the suitcase when the search of the bag was first?
And I should have argued that in the Commonwealth's
You
appeal.
conceded it.
And I
I
erroneously
Well, I guess,
conceded it.
all right, so then that answers the question, because I was going to say that it seems to me that if the consent to the search, but that wasn't the basis on which he
No.
suppressed it. Okay.
No. But and I'd like to point out to the court, if I may, that in the appeals court's reliance upon the state of Washington case, the 2007 Evans case is completely an opposite. In Evans, we have here a search warrant being executed at a dwelling, home in a garage. Defendant is arrested upon finding methamphetamine in the garage. He's under arrest in cuffs in a police car, read his Miranda rights, and then they say, and by the way, Mr. Evans, can we search your truck that's not included within the search warrant? And he says, go right ahead, only if I can be there with you and observe the search. When the suitcase, briefcase is produced from the truck, defendant says, that's not mine, but more importantly, he objected to the police seizing it. I would say this is a completely, entirely different scenario than we have here, where we have both Mr. Augello and Mr. Aragoni very much cooperating with the police without coercion. They never say to the police politely, please leave now, as they could have when they start focusing on the suitcase or even on the gym bag. Instead, they pick and choose which property is theirs, which property is not
How
theirs.
can you distinguish this case from the principle in Straw? If this court held in Straw that throwing the bag out the window, by throwing the bag out the window, the defendant indicated an intent to keep it, to retain it, to go back to it later, how can, don't we then have to say that the keeping of the suitcase in the apartment and denying that it was theirs indicates an intent to go back to it later?
Because the point in Straw is that the defendant, by tossing it out the window within the curtilage, gave the court an opportunity to say the police seizure of the bag within the curtilage is the governing factor here.
But we're within the curtilage here, we're in the kitchen.
The problem is, though, Mr. Straw was not present when the police encroached upon the curtilage in the backyard. He was under arrest in the house. And the police, or the Commonwealth rather, argued that the reason why the police obtained or seized the briefcase was they had an exigent circumstance because they thought that Mr. Straw or his family could retrieve the briefcase. That argument cut right against the Commonwealth's case. There was none of that here because here, when the police returned, the briefcase, I'm sorry, the suitcase is still there, even though the police have expressed an interest in it.
Isn't the best argument to Straw that it's just wrong?
Well, no, Your Honor.
I wrote it.
And I argued with Judge Brown below, and he wrote the
It ought to-
original.
And I think frankly, it ought to be overruled.
Well, Your Honor, out of respect for the precedent of this court and others, I would say that Straw is completely distinguishable because this is not a discarding case. This is a verbal abandonment
But
case.
isn't it even stronger because it's in their curtilage and they want to go back to it after the
No.
police leave? It's in the and they left it in the kitchen because that's where you drink, is in the kitchen.
No, the point is there's no indication here that unlike Mr. Straw, who took an effort to hide and conceal the briefcase from the police, albeit hurriedly, and if you had a better arm, you would probably clear the offense, and then we could take it under Chappie. But here we have absolutely no effort by the defendants when confronted by the police to hide it or to protect it by revoking consent to be in the apartment. Instead, when faced with a choice, they say, "My gym bag, not my suitcase." Unless the court has further questions, I'll
Thank
rest
you, Mr.
upon my brief.
Pielpan. I greatly appreciate you upholding well-reasoned and well-written precedents of this court.
Only one vote to overrule it.
Mr. Pollard, good morning.
Good morning, Honorable Justices. May it please the Court, for the record, I'm Jeremiah Pollard. I represent Christopher Augello, and with me is Attorney David Pixley for Roger Aragoni. Just to focus on where the argument started, there really is only a verbal disclaimer of ownership underlying the theory of abandonment here. There's nothing else other than inaction.
Why isn't that enough? Why isn't the verbal abandonment,
Verbal disclaimer, you mean?
yeah, or verbal the statement, the disclaimer, the express renunciation of ownership, why isn't that enough to carry the day for the Commonwealth?
Because the concept of abandonment is in focusing on a legitimate privacy interest that's reasonable. There's no abandonment by answering no to the question, is that your bag?
But it doesn't have to be abandoned by Augello and the other defendant. It could have been abandoned by the previous occupant of the apartment.
That would, assuming that were the case, they didn't even get that far in terms of the information they had. They said, is that your bag? The answer is no. Then he seizes it, treats it as abandoned property, and of course it isn't. It's not abandoned when it's in a kitchen next to a refrigerator. And what I think the argument that's being kind of meshed with some precedents in federal cases is that it's not so much that there's not a legitimate expectation of privacy, because there is. It's that this individual, because he disavowed ownership, doesn't have standing, and that's a different concept, and one and that A, wasn't raised below, and B, runs against the grain of this court's precedents, not only in straw on the facts of objective act to indicate abandonment, but also with respect to automatic standing.
Is that really fair, though? I mean, I took it that it's not standing as much as it is saying just that word. I'm not, whether you agree with or not agree, but I think the Commonwealth is just saying, sure, he has standing to contest it, but having said no, he has no interest in it, then he doesn't own it, it's not his. That connects to, I obviously don't have a legitimate expectation of privacy in something that's not mine. It's not a standing question.
And why are we getting into standing anyway? This court has said that over and over that you have standing when in a possessory crime for the motion to suppress.
The reason why I've raised it is because Zapata and De Los Ferrar, the cases that have been cited by the Commonwealth, engage in the analysis of when is someone's legitimate expectation of privacy not a legitimate expectation of privacy. As to that person, that's the language they use in different variations.
But we're talking about different purposes. We're talking about at the time of the search, not standing for purposes of the motion to suppress.
You can still, I take it, you can still, when trash is put out on the street, it's been abandoned for some Fourth Amendment purposes, but for purposes of standing, the defendant still has the right to challenge the seizure.
That's correct, and they have the right to challenge the seizure, but they've abandoned that trash open to the public. There can't really be a serious contention that that's the case with a suitcase that's next to a refrigerator, because it's not open to the public, it's closed. Everything they've done has evinced an intent to deprive the police of possession of it, they've not done anything to relinquish that privacy interest. And in the case where the trash is brought out, it's almost the opposite. They have standing, but then they don't have legitimate.
I take it this would be like, I mean, if you literally, the police come into your house and they're talking to you and they see a trash bag next to the refrigerator and basically ask if that's your trash, and they say, no, that's not our trash. The question is whether that's abandonment, whether that's like putting it on the street or not. You would say, no, it's in the apartment. It's not until it goes out onto the street have you relinquished any expectation of privacy, regardless of what you say about it.
That's correct, because you haven't engaged in the additional act of abandoning that privacy interest.
What's your best case here? I mean, Evans, you've cited Evans. We've looked at Evans. Is there another case that you rely on?
Well, the precedents in Massachusetts as well, Commonwealth versus Straw, I think that
But that's not an oral disclaimer case, right?
it isn't, but the court did acknowledge that the act itself, and abandonment can be couched in terms of words and actions, what you do, and what was done in that case objectively would have indicated to the police that it had been abandoned, but it hadn't because of where it was placed. And you just substitute the act of throwing the briefcase out the window with the words of no, or the word no when asked if it's yours, and it's still a legitimate expectation of privacy in the bag. Also, I think Evans is a very instructive case because that was Washington Supreme Court did analyze the concept of abandonment by a disclaimer and how that creates tension with automatic standing.
Of course, there they basically said a disclaimer, an oral disclaimer may not be enough standing alone, but where there was not only an oral disclaimer, but in that case, when the police then sought to take the suitcase, he said, no, you can't take that suitcase. I mean, that seems to me to be a different case than this.
There's certainly different facts in that case, but the defendant, and that's been raised in the Commonwealth's brief, and is also cited in discussed in some of the federal cases. It's problematic to note in those cases that the defendants didn't object or try to stop the police. That would create an interesting concept in these circumstances. I think their inaction can't be held as a further indicator. In addition to the disclaimer, it's not a reasonable basis for that abandonment piece in these cases, because really and truly the defendants are not going to be, they're going to be ill-served if they have to object or try to stop the police from conducting an illegal search. So arguably that should not be held as a strike, I guess, is the best way to put it.
Well, what about, I have to confess I haven't read it, but there's an appeals court decision, an earlier one, that Justice Brown relies on. Is that helpful to you, just in response to Justice Small, I think?
Yeah, Commonwealth versus Small actually does have an oral disclaimer. I think it was represented at the court that there are no cases in Massachusetts involving oral disclaimers, but that was an oral disclaimer case. The search had been conducted prior to the oral disclaimer, but I think in the Small case, were in federal court, it would be a prime example of how this expectation as to the person plays out, because they would not be able to bring a motion to suppress in federal court based on that disclaimer. And that's the large difference between Massachusetts.
That's a standing issue.
That's correct. Yeah. And that did involve an oral disclaimer. It was an oral disclaimer in an airport. These bags are not mine. And same exact type of piece after they'd already been picked up, and that oral disclaimer alone wasn't sufficient for abandonment in that context. And that case, Small, rejects a large portion of the federal airport cases that are cited. And the other piece I would point out for some of those federal cases is many of them involve facts in addition to the oral disclaimer. Zapata, for example, was a case where the keys were provided to the federal agents prior to the search of the car. And prior to dealing with abandonment, they discussed that general consent to search the vehicle entailed the duffel bags in the back of the car, and then they dealt with the abandonment piece. So they're facts in addition to just simply a refusal to acknowledge ownership, which in this case would have put the defendants in a tight spot. They either acknowledge they own the bag, or they're not going to be able to have a legitimate expectation of privacy. And that may be bringing me full circle with the automatic standing piece, but it's also plays into the concept of what you can expect at the core of the very heart of our Fourth Amendment in Article 14 in the home, and your expectation of privacy there. You're going to be given a do or die situation, and either acknowledging that the bag is yours or it's abandoned. I guess the next step would be, if you didn't, as argued, if you didn't object, are you now in a position where you're not exercising your expectation of privacy by telling the police you don't want them to search, such as in the Evans case?
Well, let me get back to the concept of abandonment again. Supposing the suitcase, in fact, belonged to a third party, and the police asked Augello, "Is that your suitcase?" He says no, and he asked the other guy, "Is that your suitcase?" He says no. Do the police have the authority to assume that the suitcase is abandoned and then open it?
No. It doesn't. The next question hasn't been asked. It could be Bailey's. It could be the statement from one of the witnesses was that Christopher Augello and his brother Scott Augello had been seen with a black suitcase carrying it up the stairs. There's a slew of questions that would have to follow that before you can even approach.
What does abandonment mean? Does it mean nobody has an interest in this suitcase, or does it mean that the people in this room have no interest in the suitcase?
Abandonment, in terms of our cases, have said that you've left it, you relinquished any privacy interest, and it's such that it's open to the public.
If they had asked the question after they said, it's not mine, whose is it? And these guys said, we don't know. Would that make abandonment?
I'd argue it wouldn't, in the context that would go along the straw analysis of that would indicate, as the judge had found at the motion hearing, an intent to deprive the police of the article that they're trying to seize.
What if they said no, it's not ours, and the police officer said, well then, you wouldn't mind, would you, if I open it up? And they said no. Would that consent be invalid in some way?
No, because the circumstances are, if they've asked, are you the only two who live here, and do you know who it is? And they say no, and they ask if they could search it. They're ostensibly the only available people with the authority to open that bag. And I think that that's recognized in some of the cases we're dealing with, because there are dual considerations of consent and that abandonment piece, in terms of not evincing any interest whatsoever as to whether that's open. And the facts in this case don't approach that.
Yeah, that I guess the example I'm using is sort of what didn't happen in Evans, right?
That's
Because
correct.
at that point he said, no, you can't.
Correct.
Does the record indicate how long these guys had occupied that apartment?
It does not. It does. In terms of the police report that was submitted, it was essentially as a stipulation. It was a very detailed report, and those were the facts, and they're certainly adequate for the findings that the judge ruled on the motion. And they did say that this was their apartment, that they were the tenants there, and they went and retrieved Mr. Augello, brought him back to his apartment, as they say. I don't think there's any dispute in terms of ownership and legitimate interest in terms of the apartment itself.
Did the search happen immediately after the two no's?
That's the seizure occurred after the two no's. So there was initially a seizure of 2 bottles, a tequila and a Captain Morgan's bottle.
Which were behind the bag, right?
They were on a table, I believe, in the kitchen. And then they went and retrieved Mr. Augello, the questioning in terms of the ownership of the bag, and then the bag was seized and another bottle is seen. It was treated as abandoned in the officer's words, and he picked it up, moved it, then he sees another bottle, then he ostensibly obtained consent to search the Maestro bag, finds that bottle, then opens up the black suitcase. So the judge, when he ruled that the consent there was no disconnect in between the seizure and the consent itself, which I don't believe was challenged below or when it was appealed, that piece of it.
Thank you, Mr. Pollard.
You're welcome.